Vendor Agreement Review, NDA Triage, Renewal Management, Termination Notices, the work that fills the in-house lawyer's inbox every working day, and the work that consumes most of the commercial counsel's week, regardless of how senior they are. It is the single highest volume daily workflow in in-house teams across every industry, and it has been resistant to automation for almost as long as the software industry has been promising to automate it. A traditional vendor agreement review takes 3 hours of careful work for an experienced practitioner, sometimes 2 if the counterparty paper is familiar and the matter is routine, sometimes 4 or 5 if the agreement is complex or the relationship is new. The commercial legal plugin, which shipped last week as part of the Claude for Legal release, compresses that review to 30 or 45 minutes per agreement, and the remaining time becomes the legal judgment that only the lawyer can make. The production work disappears, and what is left is the work that actually requires a senior practitioner's attention. The panel's view from the launch materials is that this is the most useful plugin in the release for in-house teams, because the architectural decisions inside it suggest Anthropic spent real time with commercial counsel before shipping. The plugin behaves the way an experienced practitioner would design it to behave, which is rarer in legal AI than it should be. One integrity note before the walkthrough begins. The panel has not yet deployed commercial legal on a live matter, and the analysis today is built on the GitHub repository, the launch documentation, and the panel's collective commercial experience, rather than on real deployment data. The deployment report comes in a later episode, once 30 days of real matter use have built up the evidence base. Commercial legal opens with a cold start interview that takes around 10 minutes to run through, and 3 of the questions in that interview do most of the work in shaping how the plugin behaves on your matters afterwards. The first question asks about your playbook positions on the major clause categories: liability caps, indemnity direction, limitation of liability, termination rights, intellectual property ownership, data processing terms. The clauses your team negotiates over regularly, and the standard positions you take on each one, including the acceptable ranges and the hard no's. This is the foundation of the practice profile, and the time you spend on it determines whether the plugin reads your team's actual preferences or defaults to a generic commercial counsel position. The second question asks about your escalation chain. Who approves what, at which dollar threshold or risk classification, and what the path looks like when the counterparty is pushing on something outside the standard positions. The plugin uses this to populate the named approver on every red-flagged escalation it surfaces. The third question is the one the panel found most revealing, and it is worded almost casually in the interview. What is the thing that makes you groan when it hits your desk? The specific clause type or counterparty pattern that drains your week, the one you wish you could hand off but never quite can. The plugin uses the answer to prioritize where it does the heavy lifting in your workflow, and the question itself reveals something useful about whether the plugin was designed by people who actually understand how commercial counsel work. After those 3 questions, the plugin asks for 5 to 10 recent signed agreements, 20 if you can manage it, because it needs to see how your team actually negotiates rather than how you say you negotiate. The gap between stated playbook and actual practice is real in every in-house team, and the plugin learns from the signed agreements rather than from the stated positions alone. Before any of the workflows actually run on your matters, the plugin asks one question that shapes every behavior afterwards, and getting the answer right in the first 90 seconds of setup matters more than almost anything else in the configuration. The question is whether you are building a sales side playbook, a purchasing side playbook, or both. If your team sells the product or service, you are the vendor and the agreements are usually on your paper, and the plugin should behave as a protective side reviewer, trying to limit your exposure and maximize your rights. Liability caps are protective. Indemnity flows from the customer to you for misuse claims. Termination rights stay conservative. Intellectual property stays with you on the product side. If your team buys from vendors, you are the customer and the agreements are usually on their paper, and the plugin should behave as a watchdog side reviewer, trying to limit the vendor's exposure shifting and maximize your. Termination and data rights. Liability caps push higher. Indemnity flows from the vendor to you. Termination rights become flexible. Data rights become paramount. The same clause in the same agreement looks completely different from these two perspectives, and the plugin's behavior on every downstream review depends on which direction you set in the first 90 seconds. If your team handles both, you tell the plugin both, and it maintains two separate playbooks, switching between them based on the agreement type. Most in-house teams need one direction or the other primarily. Software as a service companies usually sell. Enterprise customers usually buy. Get this answer right at the start, because reversing it later means rerunning the cold start interview and rebuilding the practice profile. The work that the vendor agreement reviewer is built for is the workflow that defines commercial counsel practice for most in-house teams. An incoming vendor agreement lands on your desk. You review every clause against your playbook. You flag the deviations. You suggest the red lines. You produce a deviation memo that an associate or junior counsel can act on, or that you can use as the basis for the negotiation call. Traditionally, this is 3 hours of careful work per agreement. The panel's view is that this is the strongest workflow in the plugin, and the architectural choices around it suggest real attention to how senior practitioners actually do this work. Every flag the plugin surfaces carries the specific contract language that triggered the flag, the specific deviation from your playbook, the suggested redline language to fix it, and the named approver for the escalation if the redline goes outside acceptable ranges. The 3-tier flagging is the right architecture. Green flags mean the clause is within your playbook and acceptable as written. Yellow flags mean the clause is negotiable but needs attention. Red flags mean the clause requires escalation to a named approver before signing. Where the gaps show up, predictably, is in the judgment calls. The plugin can tell you that a yellow flag exists. It cannot tell you whether to push on it in this particular negotiation, because the answer depends on the relationship context, the strategic value of the deal, and the counterparty dynamics that only a practitioner can read. The plugin produces the memo with everything you need to make the call. The call itself stays with you. The connectors that matter for this workflow are DocuSign or Ironclad for the contract intake, Microsoft Word through the M365 Surface for the redline output, and Slack for the escalation notification to the named approver. The plugin runs as a continuous workflow rather than as a one-off review tool, which is the architectural choice that distinguishes it from the previous generation of contract review software. The work that the NDA triage workflow is built for is the part of commercial counsel practice that consumes the most time relative to its strategic importance. Incoming NDAs land in your inbox, often dozens per week, sometimes more during M&A activity or business development cycles. Each one needs to be categorized as standard approval, counsel review, or full negotiation. The work has traditionally fallen to junior associates or paralegals, and the calls have often been inconsistent across reviewers because different people apply different thresholds. The panel's view is that NDA triage is the cleanest fit for a managed agent workflow anywhere in the plugin, because the questions are highly structured and the answers are mostly binary. Is the NDA mutual or one-way? What is the definition of confidential information? What is the term length? What are the permitted disclosure recipients? What is the residuals clause? The plugin checks each of these against your Playbook defaults and routes the NDA accordingly, with consistency that improves immediately upon deployment. The gap that shows up here is counterparty intelligence. Some NDAs look standard on their face, but come from counterparties where the relationship history changes the analysis, and the plugin does not know your last 3 engagements with that counterparty unless you tell it. A junior associate who has worked with the company for 2 years remembers things the plugin will not. The verification protocol still applies. The connectors that matter for this workflow are DocuSign for intake and Slack or email for routing the greenlight approvals and the Counsel review notifications. The workflow runs as a continuous queue rather than as a batch review, which means the categorization happens within minutes of receipt rather than at the end of a weekly review cycle. The work that the Renewal Tracker is built for is the part of commercial counsel practice that, in the panel's experience, fails most quietly and most expensively. Every vendor agreement has a cancel-by deadline, usually 30, 60, or 90 days before automatic renewal, and missing that deadline means the company is locked into another term, which is sometimes acceptable, but is often not. Traditionally, this work sits in a paralegal's spreadsheet, often neglected until it becomes urgent, and the costs of missed deadlines accumulate quietly across the contract portfolio. The panel's view is that this is the most quietly valuable workflow in the plugin, even though it is the least glamorous of the 4. The Renewal Tracker reads your contract repository, identifies every cancel-by deadline in the next 90 days, and outputs them grouped by urgency. Red for the next 30 days, yellow for the 30 to 60 range, green for the 60 to 90 range. The output is a clean weekly briefing, the kind of document that should have existed for the last 20 years, but has been almost impossible to maintain manually across a large contract portfolio. The gap that shows up here is the business decision on whether to renew, renegotiate, or terminate. The plugin surfaces the deadline. The business owner makes the call. The lawyer documents the decision. The plugin does not make any of the strategic choices that determine which deadlines to act on, and that is the right division of labor. The connectors that matter are iManage or NetDocuments for the contract repository, Excel through the M365 surface for the weekly briefing, and Outlook for the deadline reminders sent to the business owners. The work that the Termination Reviewer is built for is the workflow the panel underweights at its peril. Because terminations are where the careful drafting of 3 years ago either pays off or does not. A vendor relationship is ending, sometimes amicably, sometimes not, and you need to review the termination provisions of the active agreement. Notice requirements, return of data obligations, surviving terms, transition services entitlements, outstanding payment terms. The work traditionally takes a careful associate 2 to 3 hours, and the cost of getting it wrong can be material. The panel's view is that this workflow is the 4th named agent in the plugin, and the one most likely to be underused in the early months of deployment, because terminations happen less frequently than vendor reviews, and so the workflow gets less attention. That would be a mistake. The plugin reads the termination architecture of the active agreement and produces a structured notice end, exit checklist, with every relevant provision flagged and every obligation identified. The gap that shows up here is in the negotiation dynamics. The plugin produces the checklist of what the agreement entitles you to enforce and what obligations you have to meet. The strategic question of how aggressively to enforce surviving terms when the relationship is ending poorly, or whether to waive certain obligations in exchange for a clean exit, depends on the relationship context and the litigation appetite. And those are practitioner judgments that the plugin does not attempt. The connectors that matter are iManage or Net Documents for the active agreement, Microsoft Word for the termination notice draft, and DocuSign for the signed notice itself. 3 things determine whether the plugin actually works on your team, and getting all 3 right at the start of deployment matters far more than any individual workflow tuning that comes later. The first is the sales side or purchasing side answer in the cold start interview. Getting this right in the first 90 seconds is non-negotiable because the wrong direction means the plugin's defaults will fight your team's actual practice for months before anyone notices. The panel cannot overstate how much this single answer shapes everything that follows. If you sell, the plugin should be protective. If you buy, the plugin should be a watchdog. If you handle both, the plugin needs to know which agreements fall into which bucket. The second is the 5 to 10 signed agreements you share during the setup interview, and 20 is genuinely better than 10 if you can manage it. The plugin needs to see your real positions, not just your stated positions, because the gap between what your playbook says on paper and what your team actually signs in negotiations is the gap the plugin needs to learn. Underbuild this corpus, and the plugin defaults to a generic commercial counsel position. Build it carefully, and the plugin reads your team's actual practice. The third is the Playbook Monitor agent, which is the architectural feature that distinguishes commercial legal from every other contract review tool on the market. The Playbook Monitor watches every agreement that flows through the plugin in regular operation. When your team's actual decisions diverge from the stated playbook, the monitor proposes a playbook update for your review. Your practice profile gets sharper every week the plugin runs. The setup compounds in the way that a junior associate's understanding of the firm's positions compounds over the first 3 years on the team. Build the profile carefully at the start. Maintain it through the monitor as the plugin runs. The plugin reads your team's playbook the way your best associate would after 3 years of working with you, which is the threshold at which it actually becomes useful rather than just impressive. The commercial legal plugin handles contract review with sophisticated playbook intelligence, but the durable verification skills the panel has covered in the Foundations series still apply in full, and the practitioners who skip them in favor of trusting the plugin output are setting themselves up for a particular kind of mistake. Verify every citation, from Foundations number 6, applies to every legal authority the plugin cites in support of a redline suggestion. Some of those redlines are pure house style and do not need authority backing. Others rest on case law or statutory authority, and the verification step on those citations is exactly the same as it would be for any other research synthesis the plugin produces. The 15 minutes a careful citation check takes is the cheapest insurance available in commercial practice, and the plugin does not eliminate the need for it. The 5 Qs protocol, from Foundations number 7, applies to every case the plugin references in support of its recommendations. The sourcing layer that the plugin inherits from the broader Claude for Legal release reduces fabrication risk substantially. It does not eliminate it. The 5Q check takes 90 seconds and remains the standard for any citation that makes it into a contract negotiation, a deviation memo, or a board briefing. Build a chronology in an afternoon, from Foundations number 5, becomes the documentary check on whether the plugin's account of the contractual relationship matches the actual sequence of negotiations and amendments. This matters especially on renewals and terminations, where the relationship history determines the analysis, and the plugin can only work from what it can see in the documentation. The foundation skills are the verification layer that keeps the lawyer in charge of the work the plugin accelerates. Step back from the 4 workflows for a moment and consider what commercial legal does to an in-house team over the medium term, because the implications go beyond productivity improvement and reach into how the function itself is organized. The function of in-house commercial counsel changes shape when the plugin is running at scale. The traditional role of commercial counsel has been gatekeeper, reviewing every incoming paper line by line, making the calls on each deviation, and serving as the bottleneck through which all contract activity flows. The plugin does not eliminate that role, but it transforms it. The new function is Escalation Handler, making judgment calls on the deviations the plugin surfaces rather than reviewing every clause from scratch. The production work compresses by an order of magnitude on the review side. The work that remains is the work that actually requires legal judgment. Inside 2 years, the panel thinks the question commercial counsel get asked at job interviews changes materially. The traditional question has been some version of, how do you handle high-volume contract review? With the expected answer involving efficiency systems, prioritization frameworks, and team management approaches. The new question becomes some version of, what does your playbook look like, and how do you maintain it? The playbook becomes the asset that distinguishes one commercial counsel from another. The plugin becomes the leverage that makes the playbook valuable at scale. For senior commercial counsel with the seniority and the context to build and maintain a sophisticated playbook, this is the most valuable productivity release of the year. For counsel who have built careers on high-volume review hours, the function is changing under their feet, and the practitioners who recognize the shift early are the ones who will be best positioned when it arrives at their door. That was the walkthrough. The 4 named workflows in the commercial legal plugin, the cold start interview that shapes how each one behaves, the playbook split that flips the architecture, and the strategic implication for how the function of in-house commercial counsel evolves over the medium term. The deployment report comes in a later episode, once 30 days of real matter use have built up the evidence base, and that episode will name the failure modes the panel finds in practice rather than the ones anticipated from the launch materials. The panel expects the sales side and purchasing side split to be where the most unexpected behaviors emerge, and the deployment report will surface those. In the next Unpacked episode, the panel goes through the Research Connector workflow. Westlaw, Practical Law, and Court Listener inside Claude. The architectural piece that addresses the hallucination questions structurally, because the model is reading from the authority databases your firm already pays for, rather than from the open internet. The episode walks through where it works, where it does not, and the verification protocol that still runs alongside everything the connector layer makes possible. If your practice touches commercial work in any meaningful way, the Commercial Legal plugin is the single most material change in the Claude for Legal release for in-house teams. Adopt it carefully. Build the practice profile thoughtfully. Maintain the Playbook Monitor. The lane is moving fast, and the firms that move with discipline now are the ones that will be best positioned when the dust settles. That's the episode. See you in the next one.